Hi, it's Wednesday, December 5th, 2012, 12:30 p.m., and we welcome you to this webinar, The Whistleblower Threat, Do You Have It, and What Can You Do About It? I want to welcome my guest, our guest, Lester Perling. Lester is a board-certified healthcare lawyer, former chairman of the health law section of the Florida Bar, former hospital CEO. Lester knows a lot about health law. Welcome, Lester.
Thank you, Alan.
Well, Lester, what do you want to tell us about the whistleblower threat?
Well, I guess there's nothing new about whistleblowers or the False Claims Act anymore. I think what is new that providers and their advisors need to understand is that the targets of whistleblowers are expanding, and whistleblowers and their counsel now appear to be more willing to bring cases against smaller practices, smaller types of providers than they previously were. And I think, no doubt, seeing that there's a potential pot of gold at the end of the rainbow, that even if the government doesn't get involved with the case, they'll get some sort of settlement out of it, or at least that's the hope. One of my partners is fond of saying that there's at least one whistleblower for every provider out there. And
wow.
I think that anybody who bills Medicare, Medicaid, et cetera, needs to assume that that's certainly the potential, at least, and govern themselves accordingly, as we lawyers are sometimes fond of saying. I don't know exactly what that means, but lawyers are fond of saying that, but I think it's true in this context.
And Lester, you represent a lot of healthcare providers, a lot of medical businesses. I assume that you have a few stories to tell where you're seeing these whistleblower cases come in against smaller practices and where the whistleblowers are earning some money and causing a lot of grief.
Well, at least, at the very minimum, causing grief. I mean, I think right now, in terms of the whistleblower cases that we're handling in my office, they range from the typical ones you might expect, the large for-profit hospital companies, large non-for-profit hospital companies, individual hospitals, durable medical equipment companies, but large medical group practices. But I think recently we started a new case that is a two-physician practice, a group of 2 radiologists. And I think that is not unique to us in terms of, like I said, at the outset, starting to see the whistleblowers and their counsel more willing to expand their horizons. Here is a radiologist practice in the northern part of Florida. The whistleblower is represented by counsel in New York City. Part of the problem, and I think this is true in this case, but I think it's probably true generally, is whistleblowers' counsel don't really know the scope of what the potential damages are until they get into discovery, to some degree anyway, and they rely on what the whistleblowers tell them. And so I think whistleblowers often, in order to get counsel to take the case, will overstate their position. Be that as it may, once the case is filed and it's made known to the defendant in the case, they've got to start spending money on it. Even if the government doesn't intervene, and even if ultimately they can make it go away, it's going to cost in thousands or even tens of thousands of dollars just to get to that point. So it's a difficult situation because it's expensive and annoying and emotionally tolling sometimes, even if the provider ultimately might prevail.
Wow. Okay, so what is the overall thumbnail sketch of what the whistleblower law is that would attract an employee to turn an employer in to earn money? What's the structure of that?
Well, I mean, the key point is what you just said at the end, is to earn money. The False Claims Act, which has been around since the Civil War, provides a bounty to individuals who bring a case in the name of the government against a individual or company that submits false claims to the government. And obviously not only healthcare, it's any type of claims. We're concerned about healthcare, but the draw for the individual, the employee or the former employee or the spouse, former spouse or mistress or anyone else who may have information, is that they are subject to potentially getting a percentage of the recovery that the government makes. The percentage is going to vary case by case, but it could be as much as 30 to 40% of the recovery. So, you know, a $1 million recovery could bring as much as $300,000, $400,000 to the whistleblower and their counsel. Now, of course, the whistleblower's counsel works on a contingency basis, so they're going to get 30 to 40% of that, and that's their motivation. And, you know, with more and more of these cases being brought, we're seeing more whistleblower counsel being former or still current medical malpractice plaintiffs' lawyers, you know, based on because of tort reform, they may not be able to make as much money in doing what they were doing before, and they're kind of turning their litigation skills to the False Claims Act. And they're the ones who are often willing to bring the smaller cases. They're also the ones that make it more difficult because they don't really understand the False Claims Act. They don't understand the substantive Medicare, Medicaid rules that they're trying to deal with. They just listen to the whistleblower, file a lawsuit, and go from there. You know, we'd much rather be dealing with experienced, with False Claims Act plaintiffs' counsel on the other side than this new crop of sort of just at the risk of offending someone, run-of-the-mill plaintiffs' lawyers who are now bringing some of these cases. We don't really understand them.
Wow. Yeah, it makes it more expensive to defend, and they're willing to take much bigger risks.
And then, like I said, they don't know, and they don't have a good case that they shouldn't be bringing because they really don't understand what they're dealing with. An experienced whistleblower's lawyer will often send potential clients away because they understand the regulatory scheme. An inexperienced one may not do that.
Right. So if a whistleblower files a case and the doctor has to pay the government back $200,000 because he's been coding a particular test or procedure wrong, what does the whistleblower earn of that $200,000?
Well, they can earn up to about 40%. If the government chose to intervene in the case, which means that they chose to sort of prosecute it rather than let the whistleblower prosecute it, then the relator and this counsel can earn up to about 30%. If, on the other hand, the government declines to intervene, and so the whistleblower has to go it alone, which they can do, although it's still in the name of the government, the whistleblower can get up to about 40% of the recovery. Now, so in your hypothetical of $200,000, 60 to 80,000. Now that's too small amount of money that interests probably any whistleblower's counsel. And keep in mind, under the False Claims Act, the defendant is subject to treble damages and an $11,500 per claim penalty. So if your $200,000 example is single damages, then that would be up to tripled to $600,000. And then if there's 1,000 claims in that $200,000, theoretically at least, you could multiply each one of those claims by 11,500. So that 200,000 adds up to whatever that comes to, but certainly well over $1 million of potential damages.
And it doesn't have to be an intentional overbilling. It can be an accidental.
Well, not accidental. The standard in the False Claims Act is reckless disregard of the truth or falsity of the claim. What that means, basically, what that standard means is that the provider has hidden their head in the sand, that they had made no effort to learn the right way to bill. They had just sort of billed and chilled and taken the money. So it doesn't require them to know they're submitting a false claim or intentionally do it. On the other hand, if they really had tried to do the right thing, but it was truly just an error on their part, then it would not necessarily rise to the level of a false claim, but rather be an overpayment. So there has to be a little bit more than just pure accident involved, although that's obviously a moving target, in terms of what is mere negligence versus something a little bit worse than mere negligence.
Well, so that's a good reason to have a medical consultant come into your practice once a year, spend the day looking at your coding, give you suggestions, and make sure you follow the suggestions.
Absolutely, because in defending these cases, one of the things we try to point out to say, look, this may be an overpayment, but it's not a false claim, is look at all the things the provider has done to make sure or to attempt to bill correctly, and they really didn't have the requisite level of intent to submit a false claim. We admit it's an overpayment, but it's not a false claim. And in fact, sometimes we actually will refund the overpayment during the pendency of the false claims case when we agree they've been overpaid, which sort of tends to really muddy the water for the relator and the government. But in any event, that type of activity, having a compliance program that's appropriate for the size of the provider really can serve, prove to be useful in defending a false claims case if one occurs.
Wow. Okay. Let's go to the next slide, which is what can you have employees sign to prevent them from being whistleblowers?
Pretty much one word answer, nothing. There's nothing you can ask an employee to sign, like a confidentiality agreement or something like that, that would be enforceable. The courts are going to say it's void as against public policy. Now, there's been a little bit of slippage in that in settlement agreements, but the general rule is still very much, and I think will continue to be, any agreement like that is void against public policy. So, for example, let's say you have a disgruntled employee who's leaving, and you have them sign a settlement agreement. You give them some severance, and they agree not to file unemployment, not to sue you, and not to report you to the EEOC, and not to file a false claims case. While most of those things I just mentioned would be enforceable in court if they tried to do it, under the False Claims Act, it would not be. And the reason is when you're suing under the False Claims Act, they're not suing for themselves. They're suing on behalf of the United States of America. And because the United States of America was not a party to that settlement agreement, the relator essentially can't say, okay, I agree that the United States is going to waive its right to sue you for this $20,000 check I'm getting.
Wow. Is there any way to make the whistleblower a co-conspirator by requiring them to immediately notify the employer of any deviation from appropriate law and appropriate billing techniques?
Well, every employer, anyone in the healthcare world now should have a compliance program and policies, and one of those policies should certainly be that employees are obligated to report any potential deviation from policy, any potential violation of law, etc. Now, that, again, isn't going to prevent them from filing a claim and becoming a whistleblower. There are battles oftentimes in these cases between the government and the whistleblower about how much money they should get. And there are whistleblowers who come with unclean hands. And the government has sometimes argued that those whistleblowers should get zero. And the courts have sometimes enforced that. What it often does, typically would do, though, it may not go down to zero, the whistleblower share. The court may reduce the whistleblower share from what it might otherwise be to a lesser amount, because ultimately the court has to award the whistleblower its share of the bounty, if you will. So unclean hands certainly can impact that. The failure to report may or may not is not as clear, and it really is going to vary based on the judge and the government lawyer in the case. But that is always something we look for, to try to undermine the whistleblower in terms of the amount of money they may get, particularly if the government declines to intervene. And but even then, the government will still be involved in the process of awarding the. We're trying to perhaps limit the award that's given by the court to the whistleblower. it isn't the government's, it isn't the U.S. attorney's decision how much money the whistleblower gets. It's the court's decision.
Okay. Now, you said something interesting, which was you said every practice should have a compliance program. But I think a lot of times when a 2 or 3 doctor group calls a medical consultant and says, I want a compliance program, it becomes a $20,000 exercise versus having a reputable billing consultant come in one day a year to go through a few charts and make some pointers and making sure that all the employees sign the proper paperwork to show that they're being asked to tell the employer immediately if they know of any deviation from good medical practices. I know that's not a full compliance program, but is that 70 to 80% of what a small medical practice really needs?
Yeah, I mean, compliance programs got to be geared to the size of the practice. I mean, for the, a small medical practice, you got to look at what, in any healthcare organization, you have to first say, okay, what are the risks in this practice? Well, for a small medical practice, the primary risk will be billing. And so having an audit if the doctor's done once a year, where a billing consultant or coder, certified coder, does a sample of all of the various codes that are billed by that provider, and provides a report. The provider takes corrective action, documents that action. That could still go a long way to try to help protect that provider. There are other risks, though, that a billing consultant won't see, that even a small practice could have. So let's say, for example, the physician has a medical director agreement or some sort of agreement with a hospital, and that agreement is a problem. Let's say it's really a disguised kickback. That could become an issue even under the False Claims Act now too, because the False Claims Act was amended to specifically state that claims submitted that are associated with kickbacks are false claims. So it isn't all about billing and coding. So I think a provider, any provider physician who is going to engage in business relationships with other providers, hospitals, nursing homes, home health agencies, other medical groups, where there's compensation changing hands or remuneration of one form or another, should have that agreement reviewed by competent counsel at the time it's entered into. I mean, once it's done, it's done. But those things can turn into risks too, and we see that with physician clients who end up in the soup because some company's given them an agreement that they just think, oh, this must be okay, and they sign it, and it turns out it isn't quite so okay. So, again, the provider's got to assess their risks. And billing and coding under the False Claims Act is still the primary risk, but there's relationships that could get the provider in trouble as well, particularly in relationships with other providers. So the practice, the average 1 or 2 medical practice, those may be really the 2 key risks. Billing and coding still being the primary risk. And it doesn't, a doctor practice doesn't have to have a huge compliance program and a compliance officer, but keep in mind, technically a compliance program, in order to be a shield against a criminal charge, and to some degree a shield against a civil false claims case, it has to be quote-unquote effective. And there are 7 elements to an effective compliance program that go beyond just doing the audit. But believe me, in defending a physician, I'd rather have them just doing the audit than doing nothing at all if there's a whistleblower case out there.
Right, right. Okay. Let me see here. The next slide is what simple compliance techniques will help insulate the practice from whistleblower exposure. I think we've talked about that. And of course, don't hire a whistleblower if you possibly can avoid it. People who make trouble in little personality ways or who seem a little bit strange on the job may be more likely to go for it and sue you on behalf of the government. Lester, 3 simple ways to spot a whistleblower situation before it happens?
Well, one would be a disgruntled employee who has openly complained about billing practices or other things going on within the practice, and they come to the doctor or the office manager and say, I think we're billing this wrong, and they're told go away, and they come back again. I mean, that's a whistleblower in the making. 2, someone who is seen, copying documents after hours or during lunch, or is discovered to be downloading documents from a computer onto a disk that they would there's really no reason for them to be doing that, is, certainly has the potential to be a whistleblower. Someone who's just disgruntled, who's unhappy with the way they're being treated in the practice and make that known, or when they are terminated, let's say, or leave, they make the statement, you haven't heard the last from me yet. Those folks are certainly also potential whistleblowers. The reality is it's pretty hard to spot them before it happens, and they often come out of left field. Or they come out of left field, and when they do, and the employer thinks back to it, they went, now that I think about it, I remember him complaining about X, Y, or Z, or I remember them standing at the copy machine. But they don't really notice, anything at the time. Of course, terminating those people when you think they're going to be whistleblowers, assuming they're still employees, can be an issue too, because it could set the employer up for a retaliatory discharge claim, both under the False Claims Act and other state and federal protections. Firing someone just because they complain about your billing or whatever is not only a good way to create a whistleblower, but it's a good way to also have to pay damages for a retaliatory discharge claim. So once you think or know someone is a whistleblower, you really need to talk to counsel before you do anything with them, because it could just create more trouble. Doesn't mean you don't fire them if there's cause to fire them, but you really have to be careful about that, because you're taking a bad situation and compounding it.
Right. Are most whistleblowers in the bookkeeping department?
No, they're often clinical. They're probably not. Most are probably clinical people, or administrators, practice managers. Probably not bookkeeping, because they don't know. It's people who understand or think they understand, that something should be billed in a certain way, and it's not, or that the service is being billed that they know they didn't perform, or the office administrator who has heard things from other employees and has tried to get the doctor to change, and the doctor won't. So most whistleblowers are either managers or clinicians.
Okay. All right. Well, Lester, anything else you want to say before we sign off here? I thought that was very informative and certainly a sad state of affairs, but eventually these plaintiff lawyers are going to learn that this is not as lucrative as they thought it would be as you beat them back one by one.
So the government just reported today that they recovered, I think it was 2012, or maybe in the last fiscal year, government fiscal year, $5 billion under the False Claims Act. That's just not health care, but a very large chunk of that now, certainly the majority of it, is health care. And that number just keeps growing. And Congress has learned that money spent on enforcement agencies is money well spent. They are getting a very good return on their money. And as long as that continues, like any other investor, why won't they keep doing it? So this isn't going away, and providers, it's going to keep growing, and the government, I think, and Congress is going to keep allocating more money to this as long as it keeps paying off in big returns. And so providers, big and small, ignore it at their peril, and need to consider what they can do given the size of their practice or company and resources available. To one, try to do the right thing, follow as best they can all the intricate policies and procedures and rules and statutes that govern these programs, but also to in the first instance, but also then to monitor their own behavior and to admit it when they're wrong and fix it, which may involve now refunding money back to the government, because the failure to refund the money once they know they've been overpaid is also a false claim. So you can be got coming and going. You can not only have a false claim for submitting the claim, you could potentially have a separate false claim for not refunding the money once you discovered it was received in error. So that only makes the pot bigger for relators.
Okay. Very good. Well, maybe we can do another one on these, on the 10 biggest mistakes a medical practice can make to end up as the defendant of a whistleblower case.
All right.
Very good. Well, we want to thank everyone who attended and everyone who views this webinar later. Tell all your friends and your family about it. And Lester, thank you again very much. If anyone has any questions, you can email me. You can email Lester. We'll be glad to answer it. And have a fantastic afternoon.
Thanks, Alan. Bye.